Taylor.
On behalf of the people.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Gregory Taylor. Mr. Taylor, please state your name for the record.
Gregory Lewis Taylor.
Thank you, Your Honor. Today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination at the very soonest date available.
I don't know if the parties are in receipt of, but the court has received, I guess, what's been entitled an affidavit of non-prosecution.
Yes, Your Honor, we were sent a copy of that.
Okay. Do people be ready to go on the 13th, or you want the 20th?
Excuse me.
One moment, Mr. Taylor.
Would we be able to have the 20th, Your Honor?
Excuse me.
One moment, Mr. Taylor. One moment. The judge will give you a chance. Your Honor,
Preliminary examination
Honor,
in person will be set June 20th, 2023, 9 a.m. That will be before Judge Fresh Hour.
Your Honor, may I respond, please?
Yes, go ahead.
We believe that the 13th would be the most appropriate date. From the affidavit, it appears to us that it is clear that the complaining witness does not want to be a participant in this. If in fact it turns out that there's not going to be a complaining witness, then there's no reason for them to go to the 20th as opposed to the 13th. Normally they would ask for.
I don't know if they know that. I mean, this is yes.
As this court is very aware, we don't actually always need the victim to go forward with this case. So I would like some time to look into this, to have my victim advocate be able to speak to the victim if possible, and to be able to see if we can proceed without her. So I would ask for the 20th.
Yeah, and I hadn't finished making my argument. If I may please be allowed to do it.
Yeah, go for it.
Thank you. It's my understanding that they have heard from the complaining witness in this matter. The complaining witness has made it clear that they do not wish to continue. Further, there are other factors that are involved in here. Mr. Gregory Taylor suffers from a serious back injury to his lumbar vertebrae, which is causing neurological damage. He's attempted to put in kites so that can be seen. At the medical facilities have been giving him Tylenol. He was finally able to get a kite to put in, and they had to up it to, I think, what, neoproxen? Is that what it was, Mr. Taylor?
Nortriptyline.
Oh, I'm sorry, nortriptyline.
It's another one. Naproxen is. Naproxen was what they did before. Now they changed it to nortriptyline, and they're supposed to add another pain medicine today, moxilin or something like that. But I haven't gotten it yet.
So he's suffering from serious medical issues while he's in the Washington County Jail. There's every reason to believe that the prosecution will not be able to go forward, even if they say that they think they'll be able to proceed without the complaining witness. Would rather find that out sooner than later, rather than have Mr. Taylor sit in jail with his medical issues for an extra week. This is something that they can expedite given all of the circumstances, given they have this affidavit of non-prosecution, given they have this sort of warning. I believe that in the interest of justice and the essence of preserving judicial resources, and certainly in the interest of not keeping an individual incarcerated for longer than might be necessary, that having them setting this matter for the first available date would be appropriate. This is not an argument I would typically or normally make, but given all of these circumstances, I think it would be very much.
Well, we don't usually get these, and I might agree with you, except that this doesn't say that the complaining witness, or to the extent that she is, will not testify.
Yeah.
All it says is she doesn't want to, but she does understand that she may be compelled to. So I don't know what that means, and I don't know. And I think, in fairness to all sides, because this came in and I don't know what communication has been had with Ms. Taylor or anything along those lines. I'm setting it within the time frame that is
Excuse me.
by statute. I don't think I'm delaying it in any way, but I'm going to attempt to be fair to both sides in regard to it. So it's 12 days out, and that's where we'll be. So I'm going to leave it on the 20th at 9 a.m.
Thank you,
Thank
Mr. Taylor. I'm sorry, Mr. Taylor.
Yes.
If you have something to say that pertains to your case, I'd advise you not to say it. If it's something.
It doesn't pertain to my case, it pertains to the prosecution's case. She
Well,
also,
no, stop. The prosecution's case involves
okay,
you.
well, it pertains to the witness.
Then I don't want you to say anything on this record. I'll come and speak to you. The court has made its ruling.
Okay, but sir, you didn't inform them that she also has a letter that she went through the advocate in place with the court clerk as well as the prosecution that she will not be participating, that she has absolved herself of any responsibility where this is concerned. She's not going to testify.
Okay, Mr. Brown, first of all, and I'm just going to lay this out, and maybe Mr. Taylor, you should listen to your attorney,
Okay,
because your attorney is telling you not to say anything to the court. Now you're talking about communications that you're aware of that have been made, or at least purported communications, where the alleged victim says now, unlike the affidavit in front of me, that she will not testify, which I don't know. And I'm not saying that you were interfering. It would be a little bit, I'm a little bit concerned that you know that. And so I think even more so that people ought to have an opportunity to look at this and make sure that it is not by your interference that this is occurring. So you probably should have listened to Mr. Brown and just been quiet, because that was not my conclusion at all until you started talking.
okay.
So, Mr.
Bond
Taylor,
will continue. Thank you.
that you're going that's going to change the ruling that's been made right now. So I would ask you not to
You
make
said
any
you're gonna
further.
ask for bond, or, and that didn't happen either. Can I terminate Mr. Brown and request the ability to hire outside counsel from the public defender's office?
Mr. Taylor, you are always free.
Yeah. If that's what you want to do, then I'm just going to adjourn. I'm not going to set it for preliminary examination. So then what I'll do is I'll just give you another probable cause date. How much time will it take you to get an attorney?
I can't do it from in here. I'm asking to be released so that, or put on bond.
Oh, well, that won't be happening. So how soon will you get an attorney?
Just leave Mr. Brown as my attorney then, because then I have to
Okay.
contact my family in order to see if they can find somebody for me.
Okay, then we'll leave Mr. Brown. You want me to leave it set for preliminary examination? Because that's what Mr. Brown asked.
Yes, go.
You do?
Yes, please.
Okay, what?
Yes, sir, please. Thank you.
All right, I'll leave a preliminary examination in place. Mr. Brown, you're still on the case.
Thank you. I do appreciate that.
You're
Thank you,
welcome.
Mr. Brown.
All right. It's been a pleasure. Thank you, folks. What do you have as a balance now, counsel?
Rent to retain $2,007.45. Cost $160. Cost $160 for a total of $2,167.45.
All right. And folks, you previously were denied through Hawk, is that right?
Yes, sir.
Okay. So how are we going to get this paid down or paid off?
I've been making payments, Your Honor, to bring the payment down.
Okay, but so here's what I remember. I think you were gonna try to move, right? Because you at a house. When were you planning on trying to do that?
To be honest, I was trying to do that as soon as possible. I just only wanted to do it. I didn't want to have an eviction on my record as if I'm abandoning the place. We're trying to pay the cost down. We was gonna as soon as possible, Your Honor.
Okay. Okay, so what, but I need a date that you're looking to try to do that. I mean, I remember everything. I remember you don't want the eviction. You don't want that. I get it. I'm just, folks have just got to answer my question so that I can try to see what I can work out for folks. But you had indicated the end of some month. I can't recall whether it was June or July. You had said that you were trying to get yourself moved.
The end of July is actually the end of my lease.
Yeah.
So we've been already looking for a place. It's just if we get an eviction on our record and the place I'm trying to move,
Okay.
we're not gonna be able to move sooner. July, if not sooner.
So, folks, do you have a place to go?
Yes, sir, Your Honor.
Okay, so when you're talking about the eviction on your record, I get why you don't want it, but you keep giving me a rationale for it that's not making a lot of sense to me. Because if you've got a home to go to, that eviction on your record is not going to make a hill of beans about you being housed, right?
It's not going to make hill of beans about me being housed right now, but if I want to be housed somewhere else in 2 years, it will. An eviction stays on your record for 7 years, Your Honor.
I've been doing this for a minute, sir. I get it. All right. But okay, how are you proposing? You know what? I'm done. How are you proposing to pay this down?
To be honest, I know for a fact I was going to bring them $1,600 on the 28th of this month. I was actually hoping to pay a little bit more before then to help bring it down, because the last time I paid them $1,600, I only owed them $600. So I'm hoping to pay some money along the way, Your Honor. But the whole thing is, as of right now, I get paid every week. But literally, today is the first. Literally on the 5th, my whole pay schedule switches. That's the whole problem I'm getting into. I go from a every week pay to a every 2 week pay. I just started my
Counselor,
job, Your Honor.
are you guys willing to work with these folks? I mean, I don't know what else to do because I can't get my questions answered.
Right. Your Honor, last time it does look like there was a discussion potentially about a conditional dismissal. We'd be willing, and Whitaker Oates can correct me, but if we do until the 13th, which would be the normal statutory period, they've stated they have somewhere to go. If they can vacate by then on a conditional dismissal, then with this being possession only, there would be no eviction for the future. And they would still get the statutory period that they would be entitled to if there was a judgment. My client would get possession back or have the right to get a writ of eviction the next business day. So that's what I would propose, unless Whitaker Oaks has something different, in order to help both parties do and achieve exactly what they want to do. Because frankly, it doesn't sound like payments coming anytime soon.
How does it not sound like payments coming anytime soon when I just gave you guys $1,600. Before I gave you guys $1,600, I gave you guys $250. And before I gave you guys $250, I gave you guys $175. And this was and you guys just took over. This is my first time ever being late on my rent. I can't help that I got sick and I had major surgery. I was in the hospital for over a month. I can't help that. I apologize.
Mr. Yates, Hickenbottom, let me just tell you something. You're not going to come into this courtroom and try to yell at anybody.
I'm not yelling at
It's not,
anyone.
no,
You guys
it's
are
not
talking
going to
down as
happen.
if I'm a
It's
tribe.
not going to, you want to try to overtalk me? Really? Do you want to do that today? I'll wait for your answer.
No, Your Honor. That wasn't my attempt.
Here's what I'm going to do, because I'm done. I'm going to adjourn this out to the 16th over the objection of plaintiff, because I know they want their judgment today. June 16th, 2023, 9 a.m. Mr. Yates Hickenbottom, I'm just going to tell you this. Maybe you should look at the way that you approach people. Maybe you should go over to the management and try to work out a conditional dismissal. It's going to be up to them and you to work that conditional dismissal out. I'm done. If they come back, you don't have one worked out, I'm granting them a judgment, if that's what they want.
Your Honor,
I'm done. Thank you. 16, 2 weeks. Court will be in recess. Lonnie versus Smith. Counsel, state your appearances.
Joe Barker, here on behalf of the plaintiff, Susan Kalani.
That's written for defense, Your Honor.
All right. And where are we? I received photographs, I believe, by Mr. Friedman that were sent in.
I just received these just before court. I've given a copy of these to Mr. Friedman.
Okay. Is there going to be a dispute or?
There is a dispute.
Okay. And what's the dispute?
Well, Your Honor, I will agree that the defendant technically complied with the court order, but certainly not the spirit of the court order. All right. In March 27th, when they asked for additional time, 45 days, so they could re-engineer the gate. Okay. And nothing was done about re-engineering the gate. So when they took out 15 feet, we did not know there was a chain link fence on the other side. They did take out the 10 slats, but the purpose was, from the beginning of this case, was to restore access that existed for 90 years at least, or at least most of the access to the backyard. So if you leave that fence, that chain link that you see there, it defeats the reason for taking out the 20 feet that was ordered by the court.
No, it doesn't.
Well, it's right in the middle of what would be the access if that were removed.
That's his gate.
Well, I know. That's the gate.
Yes, but it's within the 20 feet that was supposed to be removed. See the black mark? He did take out. I see the black mark. That's where the fence, the 10 sections were.
Hold on. The real issue was access to the back of the property.
Unimpeded access to the backyard, yes.
Right. So the location of the privacy fence, the wooden fence, may have impeded that. I then ordered a specific amount taken out so that that was not an issue. How does that chain link fence impede?
That chain link fence was behind the 10 boards that were ordered to be removed.
I just have to say, it's not a chain link fence. It goes across Mr. Smith's driveway. It's his gate.
I know. I understand.
They were given 45 days to re-engineer that.
Okay, so hold on. What you're really complaining about is a pole.
In this, yes, in the sense that if that post and the gate stays where it is, then you still have to maneuver around it. Whereas
Maneuver around it to do what?
to get into the backyard.
Oh, but
No, that's,
Look at my-
get into the backyard with what? What are you driving into the backyard?
Okay, I have to, why did we remove 20 feet if,
Because the wooden fence came up on that one side so close to the house. I mean, that pole is so far back that it doesn't, I mean, at some point, of any vehicle going in, at some point has to turn. And when I was looking at it and when I went out there, the turn was going to be the problem because it was almost, when the fence was up, it was almost like you were going into a tunnel. So turning, getting past Mr. Kalani's house is, hang on a quick second. Okay, turning past Mr. Kalani's home would potentially be a tight fit. This is not.
it's not a tight fit. That's a 5,000-pound SUV that's got 3 feet of room on each side.
this is a different photo that I didn't copy to Mr. Friedman, but I will gladly. It is now a gate in the middle of nowhere. Is he going to put something?
Okay,
I mean, is now going to put chain link?
Well,
I'm not here to decorate his property.
Okay.
I'm just saying,
Right.
what the ultimate issue was access to the back. Now, if you're telling me that as it's been laid out, there's no access to the back, then tell me that.
It's not that there's no access, Your Honor. It's that the spirit of removing, had I known when we were here on May 15th, that would still be up, I would have included in the request to have that removed. Your Honor, there is an ongoing problem with Mr. Smith and Mr. Kalani. I would like before that Mr. Kalani be allowed to testify as to what's transpired today.
no,
Do what? I mean, transpired was, okay, look, last time we were here, everybody was complaining about how many slats. I remember very clearly because I counted 9, supposed to be 10. Okay, so I take 10 slats out. That's been done.
I also, when we were here, talked about Mr. Smith's harassing. And today, Mr. Smith.
I don't want to go down that road, Your Honor.
I do, because this is an ongoing dispute.
It's not part of this lawsuit, and I don't want to hear about my client swearing at your client.
Well, shouldn't you, well, then you can file a police report for ethnic intimidation.
What he wants.
He threatened to shoot my client.
Did not. In any event, Your Honor, I don't think.
I don't have a criminal case before me.
True.
Let me just say this. And I'll presume that Mr. Kalani would get up and say that. What would you have me do?
Remove this, or at least move this gate post back, even with where the 20-foot mark was.
Because that would stop the language or behavior.
Well, actually,
How?
to tell you the truth, Your Honor, I would like to have gone back to my original request consistent.
I'm not going there. I've made my ruling.
I know.
Hold on. You want to bring up something where allegedly Mr. Smith is yelling at Mr. Kalani. And I'm asking a specific question. If I even say that what you said here was said, what do you want me to do?
I mean, because at the end, after I hear the testimony, you're gonna want me to do something that I would imagine would be directed at stopping that from happening. So what would, if that came up, what would you have me do?
You're absolutely right. There's nothing you could say or do that would stop Mr. Smith from harassing my client. Okay, I will agree with you on that. What I had hoped to come from today is that you would order that fence post back to equal with the 20-foot mark, because that was the intent, was to open that up. Had I known that that fence, the gate was there back on March 27th, when you first ordered this, they asked for the time so they could re-engineer.
Hold on a second. When we were here the last time, I think I still have the photos. That photo was, that piece is there. I mean, there's
no new evidence here.
There's really just a post that's there.
All right.
I mean, if he closed that half of the gate, then I guess I'm presuming what you're trying to say is that obstruction is just that post. And I don't see how that obstructs the backyard or access to the backyard.
Had I known that that post was not attached to the remaining 5 feet, I would have.
Well, Miss Barton.
I failed.
Well, Miss Barton, if I'm looking at the photos from the last time that we were here, and when I look at those photos, I can certainly tell that post is not attached to the fence.
The photos I had, I can see that half of the gate is visible.
I think that when she's talking about the spirit of this and the spirit of that, I think it is worth mentioning that earlier on, much earlier on, we talked about the fact that the removal, that going too far back was going to impact on that gate and on his privacy, and that the goal was to have the fence, the stockade fence, end at the back of his property so that he could secure that gate, which he can't right now. My contractor literally called me yesterday and said, "Why am I taking out these 5 feet? They're not in the way of anything." And I said, "You're taking them out because there's a court order for them to come out, and they need to come out." But so that's the answer to your question. My client is ordered to take that 5 feet out, so you're taking it out. Okay. I'll take the 5 feet out, but it doesn't make any difference. It's not in the way of anything. So when I went over there to see, and he took the 5 feet out, and that's when I pulled the big SUV in there, and it's like, why? It doesn't. I could turn around that vehicle 4 times in that backyard. It's irrelevant. So as far as the spirit of the order is concerned, it was satisfied with the 15 feet, and now he's got to figure out what to do with that gate. But in any event, he complied with your order of last week.
Yeah.
Agree that he complied with the aspect of taking 10 slats, but it was my understanding, and I was wrong, that gate was attached to the 5 feet. I didn't realize it was a separate post. I did not know that, Your Honor.
All right, look. If what Mr. Smith says is correct, that he's looking to secure that back part of his property with the gate that's there, the grand reality is, if Mr. Smith is correct in that, is that he's going to move that post. He's gonna somehow or another do something else with that gate. But it's the gate. From very beginning, I knew the gate was there. And I knew when the last time we were here that post, that the hinge basically was there. And I knew, I'm looking at the photos from last time to see, just to even give some benefit of the doubt as to whether or not I would believe that that was You know, just based on some distortion that somehow or another, that post is somehow attached to the wood fence. I had no, I did not think it was attached because it's not.
Okay, I was mistaken. I thought it was attached. And that would be an error on my part, Your Honor. But if he's going to move he intends to secure and move the post, that will be fine. If he leaves it there, and then what? If he puts up additional fencing from the post?
Okay, look.
I don't know what's gonna happen.
Look.
I don't know.
I issued an order. The parties were back. We went through painstakingly what needed to be removed of that wooden fence. Mr. Smith has complied with that. And so unless, because I still have jurisdiction over it, if you really want to do it, then you file a motion, they can answer it and I'll deal with it. But there's nothing before me right now. He did exactly what I asked him to do.
I will agree with that, Your Honor.
Thank you.
All right.
Thank you.